Political efforts to bump former President Trump from the ballot are nothing new, argues a new piece in The Spectator. In fact, they are decades in the making. Political science professor emeritus at the University of Chicago, Charles Lipson, argues the Colorado decision to remove Trump from the ballot is part of a century-long progressive effort to reshape the Constitution that has centralized power in Washington, delegated enormous rulemaking power to bureaucrats, and turned judges into policymakers. Lipson argues the process to nix Trump from blue state ballots started way back with President Woodrow Wilson in the early 1900s, and then became truly ascendant in the 1940s with the rise of the living Constitution theory. As a reminder, Trump has been placed back on the ballot in Colorado, barring a decision from the U.S. Supreme Court, while Maine Secretary of State Shanna Bellows officially removed Trump from the ballot yesterday. Here's her yesterday justifying that decision on CNN.
Again, I am so mindful, and I said this in my decision, that it is unprecedented. No Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. But no presidential candidate has ever engaged in insurrection and been disqualified under Section 3 of the 14th Amendment.
Joining us now to discuss his piece and the broader implications for Trump's removal from the ballot is political science professor emeritus at the University of Chicago and Spectator contributor Charles Lipson. Thank you so much for joining us, Professor. We appreciate you.
It's great to see you, Amber, and you, Jessica.
Absolutely. So let's start with the fact that I think there's been a misconception among the right for perhaps the past 5 or 6 years, ever since Trump appointed some new conservative justices to the Supreme Court, that Democrats and the left more generally didn't really care about the courts. I mean, your piece points out quite the opposite, in fact, that for a long time they've been quite interested in using the courts to engage in this judicial activism that perhaps changes elements of the Constitution and makes it easier for them to enact progressive policy.
Oh, yes. The main change occurred in the 1930s. Up until 1937, the Supreme Court had ruled every major program that was undertaken by Franklin Roosevelt was unconstitutional. And Roosevelt famously threatened to pack the court. You may remember that during the Trump presidency, when after he had appointed conservative justices, you heard that again. And that's because the Constitution itself does not limit the number of justices to 9. And the traditional story is that Roosevelt lost that battle because he didn't add any justices to the court. In fact, he won the battle. He didn't win it because he added justices, he didn't, but because he flipped one justice's viewpoint under coercive threat, in effect, and all the others began to retire, and he replaced them. And I'll give you one example of how that worked. There are a lot of rules that the Roosevelt administration put in that were based on the idea, they just said, well, we're going to regulate this, we're going to regulate that. And then when those were challenged in court, they said, well, we have that right under the Interstate Commerce Clause, which is in the Constitution. And a farmer said, look, what you're trying to regulate in my case is grain I'm growing on my farm and feeding to my own animals. I'm not doing anything in interstate commerce. And the courts, after Roosevelt had changed them, ruled that because he didn't buy the grain on on interstate markets, and because he didn't sell the grain on interstate markets, he was affecting those markets, and therefore it was interstate commerce. Well, if that's interstate commerce, almost everything is. And what you saw until fairly recently was that kind of jurisprudence essentially allowed the federal government to regulate as much as they want and to expand these large bureaucracies in Washington, D.C. And what you're seeing now is a fight over exactly that.
So I'm curious if this intense focus on policymaking through, court cases that pass through the judicial system, then making judges policymakers, as you said. Is this partially the result of gridlock, in other words, inaction by Congress, their inability or refusal in many occasions to pass legislation, to make good policy? How much do you credit the current situation where we have so much focus on the judicial system to this failure of Congress to deliver for the American people?
Oh, I think you're exactly right, Jessica, that there's a lot of it that's attributable to that. But I would say a couple of things. One, not passing legislation is sometimes the best solution. It's not always that passing things is a good idea. Sometimes the best idea is to not do something. But what a lot of our legislation does now, and I think that if you're not, deep in the midst of it as you and Amber are and see the legislation, people don't know that a lot of legislation sets very broad parameters. It says basically we want to stop a lot of pollution, and then it says the Secretary of whatever it is, Energy, Health and Human Services, whatever, shall make this rules and regulations that implement this broad thing. So you have delegation from the Congress to the bureaucracy. And and that's a problem because Congress is not supposed to delegate its rulemaking authority. And we all recognize that on small issues, that's not a problem. But when the issue becomes very large and consequential, we want elected lawmakers to make the laws. And if they don't make laws, that may or may not be a good thing. I mean, the law itself that the legislature, Democrat or Republican, want to pass may be a bad law.
I'm seeing the analogy here, Charles, between how this centralized bureaucracy, this growing bureaucracy, takes power away from voters because Congress is delegating its authority, and what's happening with this ballot fight with Trump, wherein a select few judges on these state Supreme Courts, and in some cases unilaterally the secretaries of state, are removing Trump from the ballot and taking him as a choice away from voters, even as he hasn't been charged or convicted with what they're accusing him of, which is insurrection. Can you speak to this ballot fight specifically and how this is perhaps the tail end of this progressive takeover of the courts?
Yes, I think that's a key question. And I think it has both a legal and a political dimension. I actually think the political dimension is the most important. Trump got over 70 million votes in the last election. He's the leading Republican candidate right now. His supporters see a systematic effort by the entrenched elites and Washington bureaucrats to kick him out of office. They impeached him as many times as they could. They've gone after him for things he did during his presidency, not 1 or 2 years afterwards, but waiting until the next election cycle to bring these cases, which not only pose a threat to him if he were to be convicted, but also tie him down in court when he wants to be out campaigning. But I think that if you take the issue shouldn't be framed as what are Trump's rights, although that's the legal case. The political case is what are the voters' rights? What rights do voters have to pick someone? And if you're going to rule somebody out, I'm not saying you can. If the person was 34 years old, he or she doesn't qualify to run for president. That's outside the Constitution. But if you're going to say that a major party's leading candidate cannot run, you have to make sure that that person has all the due process rights to fight it, that the Constitution is extremely clear on why he or she can't run, and ideally that there is a string of precedents. And in all these cases, there's a problem. There's just a huge problem. And the idea that one person in the state of Maine can say, well, I've looked at it and I think there was some insurrection here and I'm going to rule him off the ballot. That's a problem.
Charles Lipson, thank you so much for joining us today on Rising and helping us break this down.
I really appreciate it, both Amber and Jessica. I look forward to talking with you again soon.
Will do. We'll be back with more Rising.